Hello, this is Mary Mack. I'm the Executive Director at ACEDS, the Association of Certified eDiscovery Specialists. And I am very, very pleased to present and moderate this panel of eDiscovery giants. We're going to have a conversation with Judge Waxse on proportionality. That's what we'll be covering today. It's an educational webinar. And our panel members, as I said, are very, very experienced in this area. We have Ignatius Grande. He is the Senior Director or Senior Discovery Attorney at Hughes, Hubbard, Reed. He's also a contributor to eDiscovery for Corporate Counsel, the treatise published by West and edited by myself and Carol Basri. Ignatius helps clients manage their eDiscovery obligations in a most efficient and cost-effective manner. He's been both a inside counsel, or he's been an inside counsel, outside counsel. He's worked as a service provider, and he's going to be bringing the outside counsel perspective to this. He speaks on topics like social media, Internet of Things. He's the co-chair of the Social Media Law Committee of New York State Bar Association, Commercial and Federal Litigation Section, and he also teaches. So we're very, very pleased to have him with us. From the service provider perspective, Mimi Singh, Associate General Counsel and Director of eDiscovery at Evolver. Evolver is also the sponsor of this webinar, and we thank them for that. And she has quite a background of product liability, white collar, antitrust, whistleblower internal investigations. And she worked for the eDiscovery powerhouses of Pepper Hamilton and Deckard. And so she's seen quite a bit of action in the eDiscovery world. And, of course, our guest today, the Honorable Judge David Waxse from the U.S. District Court in Kansas City. Judge Waxse got his JD from Columbia, became a magistrate judge in 1999, and he is one of the leading writers of opinions on eDiscovery issues. He's past chair of the Judicial Division of the ABA, currently co-chair of the Forensic Science and Criminal Justice Committee of the Judicial Division of the ABA, and has been working on justice issues for the better part of his career. He's also an observer to the Sedona Conference working groups on electronic document retention and production. And we're very, very pleased to have him. He was one of the first judges that spoke out and wrote on the issue of proportionality before the rule change, which is why we've invited him here. And he's also a contributor to the eDiscovery for Corporate Counsel as well, the treatise. So I'm just thrilled to have all of these folks here for our discussion. And so what we're going to start out is talking about proportionality and what is the difference between before the amendment and after the amendment? So if we look at the new rule, Judge Waxse, it looks similar to the old rule. It's renumbered, but what's the difference between how judges and parties are handling proportionality, with the renumbering and the addition or the changing around of some of the factors there? What do you see?
Well, it seems to me that the committee was trying to really emphasize proportionality, because proportionality has been in the Federal Rules of Civil Procedure since sometime in the 80s, and it was very seldom cited in opinions. That doesn't mean it wasn't referred to, but there's not a whole lot of written opinions prior to the rule change in December of 2015. And committee's thought was that this concept of proportionality, if they could make it be used a lot more, would be very effective in getting towards the goal of Rule 1, which is the just, speedy, and inexpensive determination of the action. So it's kind of amazing. What they did was simply move the language on proportionality from one section of Rule 26 to an earlier section. In other words, it now is part of the definition of what's discoverable, when in the past, the person who thought something was not proportional could file a motion for protective order asking for protection from this disproportional discovery situation. So it's going to be interesting to see whether this has the desired effect, because I think the first problem is we have seen many times over the years rule changes take a while to get into the mindset of counsel. So you already see some reported decisions where judges are kind of perturbed that counsel's arguing the old rules instead of the new rules, even though they've been in effect quite a while. So that's one issue, is when will people discover this and figure out how to use it. And the same thing goes with some judges. They sometimes don't keep up with the details of rule changes. So it's, I think, going to be a while before we see if it has the desired effect. I mean, there are now some opinions dealing with it, but there are a lot of unanswered questions about how this is going to work, because in addition to moving the language, they changed the sequence of that list and added the first one, which is the importance of the issues in the case. And just to be upfront about this, I think that this is one of those concepts that, if used correctly, could help. But my problem with it is, like the first factor, the importance of the issues. You know, I've been doing this for 18 years, and I haven't had a case yet that I remember where the counsel are agreed on what the importance of the issues are. The general situation is you get a plaintiff who thinks this is the most important issue to be decided by the court in years, and you get a defendant who says, Judge, this is just a waste of time and money. This isn't important at all. So then the question becomes, how does the court decide what significance to give to that disputed issue? And I don't know the answer to that. I mean, it seems to me there are some cases, for example, the amount in controversy, that one is fairly fact-specific, and yet I haven't seen a case where you, maybe I shouldn't say I haven't seen a case. I haven't seen very many cases where counsel and the parties are in agreement on what is the exact amount in controversy. You know, the stock response I get when I ask at case management conferences, the plaintiff in a damage case is generally saying millions, and the defendant saying defense verdict. And how do you weigh a factor when you have no idea what the answer is? And the situation I keep running into in terms of discussing this with counsel is, if you get an agreement on what's the exact amount, you're very close to having a way to settle the case. But the normal big dispute is, you know, what's really involved. And then you get down to the resource one, you know, that also has the same problem. Are you going to do discovery on how much resources they actually have? And then when you get to the cost that's involved, you know, I've had cases where, in fact, the story I generally tell is about a nationwide class action where the plaintiff asked for a huge amount of discovery, and the defendant filed, this was under the old version of the rule, filed a motion for protective order saying this was not proportional and unduly burdensome. And they attached an affidavit from an officer of the defendant saying, if we have to comply with this discovery request, we estimate it'll cost $32 million. And so there was nothing in the affidavit that explained why it was going to cost $32 million. So I set it for hearing and told the defense counsel I wanted that affiant in court at the hearing. Of course, the first response was, he said, she's in North Carolina. I can't. I said, if you want a protective order, get her here. Well, as I sort of anticipated, the week before the hearing, I got an amended motion for protective order because in preparing for the hearing, they realized there was no way they could come up with $32 million worth of cost. So their amended motion said that they thought it would cost $2 or $3 million. So we start the hearing,